Can you disinherit an heir in your last will? Imagine you want to change your mind about who inherits your estate. Maybe you have a child who has caused you concern or a family member you no longer wish to include. The question is, can you actually exclude someone from your will? The answer is yes, you can disinherit an heir in your last will. But it's not as simple as just not mentioning their name. You need to be clear and specific in your language to make sure your wishes are followed and to prevent legal disputes. To properly disinherit someone, especially a child, you must explicitly state in your will that you are disinheriting them. Just leaving their name out might lead to them claiming a share of your estate under laws that protect certain heirs. For example, some states have laws that requiring a minimum share for minor children or dependents, regardless of what the will says. Louisiana has forced heirship laws that guarantee certain children a specific portion, unless you have a valid legal reason for disinheritance. It's also helpful to include a reason for disinheritance if possible. Courts are more likely to uphold your wishes if they see a reasonable explanation, like financial irresponsibility or estrangement. However, avoid making accusations or vindictive statements, as they can lead to disputes. Another important point is to be aware of protections for certain heirs. Some jurisdictions requiring that minor children or dependent adults receive a portion of the estate, no matter what your will states. This means you might need to plan carefully if you want to disinherit them fully. Adding a no contest clause can also help protect your estate plan. This clause states that anyone who challenges the will and loses will forfeit their inheritance. It's a way to discourage heirs from contesting your wishes, but it's not foolproof. Disinheritance can be challenged if it's proven you lacked the mental capacity to make the will, or if someone influenced you improperly. To avoid this, it's essential to work with an experienced estate planning attorney. They can help you draft a clear, legally sound will that reflects your intentions and complies with state laws. In practical terms, you should identify all potential heirs in your will to prevent accidental omissions. Use precise language to state your disinheritance clearly. Review and update your will regularly, especially if your relationships or laws change. In summary, disinheriting an heir is legally possible but must be done carefully. Explicitly state your intentions, understand your state's protections for certain heirs, and seek professional help to make sure your will is valid and enforceable.